Thank you.
No, anyhow, you know the issues. Yeah, thanks.
Hello. Diana, can you let them in the back know that I need the files on Mr. Featherston's case? Thank you. Oh, Featherston's, yes, yes. Well, I need Featherston's client. Thank you. And I need to make sure all of his motions are in there. Well, today is Wednesday, but for some reason it feels like a Friday.
Oh.
And the case on counsel, the case on Rios, I guess, oh, they found it for me, Caroline. Thank you.
Oh, they got it.
Yeah.
Oh, okay.
The case on Rios,
Yes, Your Honor.
are you doing the motions for the aggravated assault?
Yes, Your Honor.
Okay,
It appears to be 701 cases.
okay. All right, and state, is that being dismissed?
That's what it looks like at this point, Your Honor. I haven't the final decision, but it is.
Okay. Good morning. Okay, this is Jason. This is the first time I've seen you come in with the mask. What do you have to tell us?
That's just like an air of mystery.
Okay.
I woke up this morning, I had a bit of a stuffy nose, a bit of a sore throat, and a bit of a headache. They're all very small, but in case I'm getting sick, I just don't want to spread it on anything.
Thank you so much for that. Other people just come in and they breathe over everybody. My mom appreciates that. All right, so on Mr. Martin Lee Rios, everyone just let me know when you're ready. I don't know, Mr. Ferguson, if you and Mr. Garahan had a chance to conclude review of their motions.
For which, for Rios?
Rios.
Yes, I just gotta grab them out of.
Okay.
Judge, do you want us to sit at the tables or up in front or? how?
Oh, whichever is most comfortable for you all. I think the motions are they lengthy?
I just need a place to be able to write as you rule.
Okay, if you don't want to sit down, that's fine with me.
Up to you.
Sit up here. Let's just do it up here, I guess.
Oh, I don't know if you want to, I don't know if the
We don't have
court
a-
reporter wants people hovering over her.
Oh, she doesn't? Well, goodness gracious. I thought I was good looking. I'll sit back here, Your Honor.
All right, and if we can have your client come over.
Okay, that'd be good.
All right.
Sorry, Steve. Let's see right here. Okay.
But it won't work.
No, I must.
Your Honor, if I may inquire, do you have a copy of the motion?
Yes, I'll call the ones out that I have, and we can proceed on them as I have them, if that's okay with everyone. All right, Diana, Mr. Featherston wanted to put his notebook and everything right in your area so that he could write things down. I told him no. You know what my mom always says? no is a complete sentence. I'm like, okay. But it's Wednesday. It's going to be a great day. All right. Court is going to call 2022 CR 10144, State of Texas versus Martin Lee Rios. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Robert Feathers, Your Honor.
All right. And are you Martin Lee Rios?
Yes, ma'am.
All right. So we're here. Defense, you have motions. The first motion I have is a Brady motion for criminal records of state's witnesses and co-defendants.
That's correct, Your Honor.
All right, state.
Yes, I'm sorry, Judge, would you like me to respond to it? or-
Yes.
Okay.
And you can, and both parties, you can remain seated.
Thank you, Your Honor.
I don't take that as a sign of disrespect. It's easier for the microphones to pick up so I can hear better.
All right, good. We have more. I'll try to speak up. On this one, Judge, I did talk to Mr. Featherston about it. State does supply the TCIC in the file, and I believe he was in agreement with that, that if we had any issues with it, that he would bring it up to the court or bring it up to the state and we would supply it. We don't make copies and we don't upload that to e-discovery for purposes for the state, but I think we're in agreement on that.
We are, Your Honor. As long as I have access, I'm good.
All right. And the court is aware that certain documents you're not allowed to make copies of. So what I'm going to write is I'm going to grant the motion. And what I'm going to say is that the defense is allowed to have access to the criminal records.
Thank you.
And let me write this in. And you also have in this motion defense that this material is to be given to you by a certain date and time. I'm assuming that that's no longer needed. Is that correct?
Judge, today's just fine.
Okay. State, are you okay with today?
If he needs access to it, he just has to. They should have took a judge and I can give him access.
Okay. And Caroline, do you need to put these in the system? Because if you do, I'll hand it to you as we do them. All right, the next motion is to require the state to reveal agreements entered to between the state and its witnesses. And state, I'm assuming there's no objection to that.
I'm sorry, Judge, I'm just starting printing.
No problem. It's a motion to require the state to reveal agreements entered into between the state and its witnesses. I'm assuming there's no objection.
No, there's no objection to that, Judge.
And on here, it says the information to produce, and there's a blank for date, counsel.
Today's fine, Your Honor.
All right, but what happens if an agreement is made during trial?
Then I need to know about it.
No, I mean, you're saying you want it today. But
Judge,
I'm saying,
if there's an existing agreement, I'd like to know about it today. If an agreement is made during the course of the trial, I'd like to be informed of it outside the presence of the jury.
okay. All right, and state, do you have any agreements to tender to counsel?
Not that the state is aware of this point, Judge.
Okay. So do y'all want me to put in here that the information is to produce as soon as the state is aware of it, or as soon as they
That's
have?
just fine, Your Honor.
Okay. All right, so I'll grant it, and I'll say that the state is to produce agreements as soon as the state is aware of any agreements between the state and its witnesses. That way, if the state makes an agreement with someone during the trial, they won't violate this rule by not giving it to you before the agreement is
Thank you, Your Honor.
given. All right. The next one I have is a motion for list of state's witnesses prior to trial.
No objections to that.
Okay.
Today on discovery for that is fine. For the defense line.
All right, and State, do you have the witness list available today?
No, I do not, Judge.
Okay, so Mr. Featherston?
Judge, if we're not going to trial today, 20 days prior to whatever trial.
State, when will you have a list of witnesses for defense?
I mean, 20 days before trial, Your Honor, or I can get that to him this week sometime.
All right, because we say 20 days before trial, but
Right.
you don't know when it's going to be.
I mean, until the case is thoroughly reviewed, I mean, I can give him what this is, it'd be all encompassing, and I can get that to him expedited.
All right, so if the court puts in that the witness list is to be provided by, because I'm thinking this week is criminal trial division, next week it's family violence week, unless there's some other case. Will you be able to have it by defense by March 30th?
March 30th, yes.
All right, March 30th.
And Your Honor, if it please the court, this case is not super complicated. So if that date slips a little bit with the state, I'll be okay with that.
All right, thank you. So in the witness list request, the defense is asking for name, addresses, and telephone numbers.
And I did discuss that with the defense counsel. I said that we would supply information that we have. But at times we do not have addresses and phone numbers.
So does anybody object to the court adding if in the state's possession defense?
Judge, I don't mind in state's possession, but that should also include law enforcement. And I
Oh,
don't see
counsel,
how
you can
would
remain
not
seated.
Be able to contact one of your witnesses if you don't have a phone number. At least on that.
Oh, parties, you can remain seated. I don't take it as a sign of disrespect. It's just easier for everyone to hear.
I would just say that Mr. Featherston maybe has been a prosecutor in a while. And trying to find certain witnesses without telephone numbers is very common.
Yeah.
And as in homeless individuals or other individuals. I don't know how complicated this case may be. It is an aggravated assault with a deadly weapon, just one step left for murder. So, you know, those witnesses sometimes are not the most cooperative.
All right, so if in the state's possession defense,
Judge, that'll be just fine.
okay. All right, so with regards to the witness list, that will be granted. The witness list is to be tendered to defense by March 30th. The state will provide the names, the addresses, and telephone numbers of the state's witnesses if it's in the state's possession.
Yes, Your Honor.
I would agree with that, Your Honor.
All right, thank you. All right. All right, the defendant's motion for production of evidence 612 and 615, which is refreshing the witness's memory.
And Judge, the state doesn't have any disagreement with that. It's just that I guess from e-discovery, it says immediately, which we will supply immediately in lieu of e-discovery. I mean, we have e-discovery that has a lag time at times, but we also, if we get any additional evidence, I usually try to call, email, or text the defense counsel that's involved and supply that as a hard drive disk or something of that nature. So that would be my only concern about the immediacy that number 4 on Rule 12 states, and then also on number 7 on Rule 615. Also, just the order that it looks like there's several different portions that could be granted here.
All right, let's start with Rule 612.
612, Judge.
And let's go with, because number one is just, appears to just be stating why the defense says they're entitled. So
And
let's,
state is in agreement.
all right, so let's go to number two, where they want all material used to refresh witnesses' memory while testifying or before testifying.
The state is in agreement with that.
Okay. And then number three, any and all materials not limited to field notes, audio, or video recordings, even if those items have been reduced to an offense report. So you want the raw data, for want of a better term?
Judge, if it's available, some,
You can remain seated.
I'm sorry, Judge Habit.
That's okay.
If it's available, we'd like the law enforcement officers to bring their notes if they have not been destroyed. It appears there are a lot of law enforcement officers nowadays that will destroy their notes after they paid their computer increase. It is what it is, but if they are in existence, we'd like to be able to see them.
And with regards to these field notes, you're talking about the field notes in audio, if it's used to refresh a witness's memory?
Well, there's two levels to that, Your Honor. Used to refresh their memory in writing their report, and then used to refresh their memory prior to testimony.
Okay, I'm just going based upon what I'm reading in your motion. So,
Yes, Your Honor.
so in the motion for number three, it just states that you're requesting any and all materials, but not limited to field notes, audio, and or video recordings, even if those items have been reduced to an offense report.
That's correct, Your Honor. That's what I want. I will state to the court that everything that is in the Verifix system I have.
Okay. All right, state number with regards to number three.
Number three, we total agreement with the refreshing memory, judge, if you're using those field notes, audio or video or reports. And I discussed this with Mr. Preston. If it's available, I ask my office to bring everything in, if it's available. If it's not destroyed, my understanding is not in all cases, and I don't know specifically this case, those field notes that they take at times, those are the ones that are just discarded or shredded or I guess trash. So
Yeah.
if they're available, I'll request them from the police department.
All right, defense.
Judge, I could ask no more than that.
All right, thank you. So I will put down that it's agreed to if available.
Thank you.
All right, and then for defense requests that these materials be produced immediately to defense counsel. Defense, are you asking that they be produced when witnesses testify, and if they are using it to refresh their memory, but if they're not using it to refresh their memory, then you're not asking for it?
Judge, I believe the rules say after they testify that I'm privileged to have that.
So you're not immediately.
Well, the court has set a date of 30 March for some other discovery for the use 30 March in this.
State, well, it's for when they testify. Am I wrong in that?
So that's great.
Like what is this about?
I would like them before, but I'm not privileged to have.
Well, Judge, I mean, that for the state, that's somewhat logistically difficult because, I mean, he would literally have to go probably to the police department and sit there with the detective. I mean, so we have no problem with allowing for any type of notes or reports or refreshing their memory on what they bring in or what they have in their possession, rather. I mean, even if it's not in their possession at the time and they're on the witness stand, but then to go get it and bring it back. But beforehand, it seems that it may be a little bit putting the horse before the cart.
All right.
Your Honor, the police report, I would have to have an agreement with the state in order to have that ahead of time, according to the rules. So I'll back off on that and say available at time of testimony.
Okay. All right. Thank you. So number 4 is to be produced at time of testimony. Rule 615. All right. Number 5 seems to be a discovery issue because you're asking that the state provide any witness statements to you. Has that already been done? Do you have, if witnesses made statements, has that already been turned over?
Your Honor, if it pleases the court, I believe that I have everything that the state currently has. However, for practical reasons, I have seen in the past where law enforcement or a witness will show up and they will have something that was never disclosed to the prosecution. And so that I would want it at that time.
All right, state, any objection to number 5?
No, Your Honor.
Number 6, let me see what we have here. All right.
It sort of seems like goes back to the other one with field notes and the state's in agreement if they're available. If that would be it looks like that's what sort of flushes out in this narrative there in their possession. To have it at the time of testimony.
All right, and state if you will make sure that any witnesses that are coming to testify, if you would have them bring all of their field notes if they have them,
Yes.
and all of the documents that defense counsel is asking for, if it is in existence.
Thank you.
All right, and so defense with regards to number 7, I'm assuming with that, do you want it at time of testimony?
Judge, I'd like to know about it as soon as the prosecutors know about it. I've never had a problem with this particular office trying to hide anything from me. And with respect to the prosecutors involved with this case, these guys are all honorable. I've got no problems with that. And I know that as soon as it comes into their possession, they will provide.
All right, so with regards to 7, instead of the word immediately, then should it be when in state's possession or something, Mr. Featherston?
When in state possession or when state becomes aware of it, either of those I think would work.
All right, so I'm saying that it's agreed to, and I'm adding based on upon what the parties have told me, that will be when the state is aware of the statements and or when the state has possession of the statements. And Mr. Featherston, if there's some issue that comes up where you think there's a statement and you don't have it, just let the court know.
Thank you, Your Honor.
All right, then number 8. Oh, yeah, all right. Mr. Featherston, what I can tell you on number 8, I have had juries where I've said, we're going to start at 9, or either we're going to start at 1 and something happens. And sometimes it's the defense's fault. Fault is such a harsh word, but sometimes it's the defense's fault. Sometimes it's the state's fault. And you know what I always tell the jurors? I'm sorry we were running late. I had other court proceedings that I had to handle, and it has absolutely nothing to do with this case. So I never blame either party. I always take it as, I'm the reason why we're late. Now, once the jury comes back with their verdict and they've completely done with their term as jurors, I tell them that wasn't my fault. That was the defense in the state.
Well, Judge, I don't mind you telling them that I'm the worst attorney in the state of Texas. Okay, that's a reputation I know that I can uphold.
You're awesome. All right. All right, and Mr. Featherston, on the order, because I made my rulings within the body of the motion. For your order, I just put C, internal rulings of the motion.
Thank you, Your Honor.
You're welcome. All right. Motion to discover state's expert witness. And these are stapled together for, let me see something, I think. Motion to discover state's expert witnesses. And let me see what they're asking for. Oh, so state,
Judge, yes, I just started at on number
One.
one, the state of agreed, names, addresses, and histories.
okay, and then number two,
The state is agreed on any criminal history, if any of the expert would have,
well, the criminal history of,
the whole with it, but I'm assuming that means the. So,
Your Honor, please support.
Yeah.
We have two separate motions here. We had the statement list witnesses and then the expert witnesses. And there are different things asked, but criminal history was asked in both categories. And I think the court has previously ruled that I'll just view the
oh,
criminal history.
just 1 second. Ms. Garza. Ms. Garza, hi, if you could, if you and your client could move to that end, because it's noisy for the court reporter. Deputy Laura, could they move to the other end? And if you could move that guy. All right, we're back on the record. So with number one is agreed to. Then with number two,
Number two, I believe, Judge, based on your prior ruling, I'll need to get with the DA to view that history.
okay. So I will put at number two that the defense is to have access. State any objections?
no, Your Honor.
Your Honor, on number three.
Oh, just 1 second. I have to write it in, Mr. Featherston.
Sure.
All right, and then number three,
Judge, on number three, since the lead here is Mr. Garahan, I've really got no problem with Mr. Garahan having reviewed personnel files himself. If he sees an issue, I would like him to in-camera report on that. And then the court can make the decision as to whether I need to know about it.
state,
State agreed with that.
all right, then I'm going to cross out a copy of, and I'm just going to say the personal records of all of the states, the cities and counties employees expected to testify or personnel involved in testifying of physical evidence be turned over to court for examination in camera to determine what information contained therein would be relevant or material to the defense. Is everyone in agreement with the court changing it to read that way?
Yes, sir.
I have an agreement with that, Your Honor.
All right, then next, I have motion for discovery and inspection of evidence. So we'll start with number one.
The judge, I'm sorry, number one, we're agreed.
Number two,
Looks like number two, we are agreed on.
all right, is there something in the Texas State Securities Board? What is that?
I I think that was all encompassing because I think some of these portions are all encompassing, if I'm right, Mr. President.
That's correct, Your Honor, and as we go through this, Judge, I've got really no discovery issues, but I do need to have the court sign off on this motion.
Oh, no, I understand. All right, number 3.
And Judge, in this one, I just brought to, again, Mr. Thurston's attention, all encompassing, I believe, motion here, that there's no and or co-defendant, I believe, in this case. And
Okay,
if there's any grand jury, which I'm not aware of any, I not checked, but if there is any, I would supply that to defense counsel.
all right. Any objection to the court then removing and or co-defendant?
No objection, Your Honor.
All right. And then number 4,
The state is in agreement with that, John.
number 5.
State's not in disagreement, I guess you could say.
Okay.
So that's fine, Your Honor.
Number 6,
State is in agreement with.
is this notes that the officers have, or
I'm sorry, Your Honor.
is this notes that the officers would have? Because,
The address.
yes,
It would be the handwritten notes again. And I think the court has already ruled on that and we rely on that rule.
all right. So if available, all handwritten and typed notes.
Yes, Your Honor.
Okay. Number 7,
The state is in agreement with that, Your Honor.
number 8,
I believe that's
Judge, I've
already
already-
been addressed, but the state is in agreement with that, Your Honor.
number 9,
The state's, well, I don't think it applies, Your Honor. I talked to Mr. Ferguson about this. There's no, well, the medical examiner reports portion. Any other medical reports that are in our possession, we would definitely give access to the defense counsel.
number 10. All
I
reports.
don't see that we're in agreement. It's a e-discovery, it's in our possession. We will turn that over, Your Honor.
All right. Number 11.
I think this is a reiteration of a prior, if available, and also the portion Texas State Security Boards is all encompassing, so I don't believe that applies, but if available, Your Honor, the state is in agreement.
Number 12.
Your Honor, please support. I think the board has ruled on that. And I'll see the state about that in person.
All right. So number 12, are you waiving it from this motion?
To this first.
Number 13.
And Judge, this is one of those ones that the state, again, feels like a little bit all encompassing, but TCIC and sensitive documents, I believe give access to defense counsel. If there's any issue, defense counsel bring it forward to the state or for that matter, to the court.
All right. Defense, any objections to be and provided access to it?
No, Judge, access is just fine.
All right, then the court will write on 13, state will provide access to any pen packets and of course, the certified government documents and so on. So that will be granted. Number 14.
Judge, I'll abandon number 14. There's no problem.
Okay. And so the record is clear. The defense has waived that, but that has been addressed in another motion. So the defense counsel is not waiving that he be given that. It's just been addressed in a previous motion.
Yes, Your Honor.
Yes, Your Honor.
All right, number 15. And I'll remove the word co-defendant.
I'm sorry, Judge.
And number 15, I'll remove the word co-defendant,
Okay.
but any objections state to 15?
No, and I'm not aware of anything that we have that's in our possession, so, if known, we will, I don't know if this is saying that they would want to go to the property room or see an original. I think that's just a question the state has.
All right. And Mr. Featherston, you're not talking about property that your client has at the Bexar County Jail at this time. You're talking about property associated with the allegations in this case?
That's correct, Your Honor. I think property that's the defendants that's at the jail is not subject to this particular paragraph. However, if the lead detective or other law enforcement personnel that responded to the scene have still retained something, then I think it would apply to that.
All right. 15, any objections, state?
No, not to that. No.
Number 16.
I did speak with Mr. Featherston about this. It does say not including attorney work product. So I think if there's any issue that Mr. Featherston feels that may or may not be work product, I think that's something that would have to be brought up to the board.
All right, Mr. Featherston.
Judge, on number 16, there are occasions when, of course, the district attorney's office will ask witnesses to come in and interview them just prior to trial. And what I am seeking is I'm seeking to know what those witnesses have told the district attorney's office without work product. So if there's a change in testimony, I've been made aware of it prior to actually doing it.
All right. So state, it appears defense is asking if a witness was interviewed and then re-interviewed, if there is, I guess, Brady or a change in their statement to the state that you let him know.
Oh, yeah, yes, we're in agreement with that, Your Honor. If there's any discrepancies with their testimony or inconsistencies, we will turn that over.
Okay. And so, and number 16, then, is it you want the notes or you want them to verbally let you know that the witnesses' previous statement that they gave them has changed?
Judge, I'm not asking the district attorney's office to change their routine in any form or fashion. If they've made notes that are not work product, I would like the notes. If they have not made notes but have taken the change orally, then transmitting that to me orally or by email or text message would be just fine.
All right. So any objection to 16, state?
No, Your Honor.
17, a list of lay witnesses and expert witnesses.
I believe that's been addressed, and we're in agreement with that, Your Honor.
Copy of the 911 recordings.
I believe number 18, Your Honor, is through e-discovery. I believe that's been turned over, but we are in agreement with that. Although, okay, it does say including transcripts, if any, as I'm aware of, right? There's no transcripts.
All right, now, number 19, copy of all text messages, emails, or other social media collected in the above entitled cause, if any, for the defendant. So,
The police report, you can strike co-defendant on that.
okay,
And at this point, I'm aware of no social media that was collected by law enforcement.
all right. So number 19, counsel, are you waiving it or?
Judge, I don't want to waive it. If it turns out after the district attorney's office has completed their due diligence that there is that material available, I'd like to have it at that time.
All right, state, any objection to number 19?
No, it's in the state's possession, Your Honor. We would be terminating it.
All right, so I'll add if in state's possession.
Thank you.
And number 20, any and all recorded audio, video, jail calls, and written correspondence of the defendant, and I'll strike co-defendant, to include transcripts, if any.
Your Honor, I did speak to Mr. Featherston about that particular case, or that number 20 rather, and mentioned that if it's in the possession of the DA's office, and I believe he was in agreement that if how we set it up is that there is a separate company that collects those. If we request those, I will upload those or give him a hard copy of those jail calls that we obtained from that company.
All right.
No objection to that.
So any and all recorded audio, video, jail calls, and written correspondence of the defendant in the state's possession then?
Yes, Your Honor. But if please support, if you change state to district attorney's office,
Sure.
I think state's a little too overbroad.
Okay. All right, and then counsel, the court does have your election for punishment. If the defendant were found guilty, the jury would assess punishment, correct?
The, Your Honor, it's my routine to file both, and then at the time of the three files to make a decision. But Mr. Rios's decision is to have the judge do the punishment if it comes to that.
Okay, all right, then could I see the both of those back, please? Thank you. All right, so with regards to the election for jury to assess punishment, counsel, are you waiving or withdrawing that?
Your Honor, at this time, I would waive and abandon the election for jury to assess punishment and move forward with the motion, the election for judge to assess punishment.
Mr. Rios, are you aware that your attorney, and you understand that your attorney is presenting to the court that if a jury were to find you guilty, you would ask that the judge would be assessing punishment. Do you understand?
Yes.
And is that what you're requesting?
Yes.
All right. So motion for hearing on admissibility of any statement by the defendant, whether written or oral or evidence resulting for same. Did Mr. Rios make a statement?
Your Honor, he relied principally on his Fifth Amendment rights at the scene. There is some scattered through multiple body cams. There are certain statements made by Mr. Rios. If the state wishes to introduce those during the course of trial, I'd like to have a hearing at that time outside the presence of the jury to ensure that this particular motion is being satisfied.
All right. So the way I do motions for statements, if it's not a long statement, I'm sorry, the way I handle motions, if it's not a long statement that the defendant has made, then we can do that during trial. Usually what I can tell you, and I'm sure you know, Mr. Featherson, because you've been practicing it a long time, if you'll speak to the prosecutors, if there is a constitutional issue or some reason why portions of his statement should not be played, if you and the state will confer over that, that way, if the state still wishes to introduce parts of it that you all agreed should be introduced, they can already have the DVD or whatever medium it's in form, they can already have that redacted.
Thank you, Your Honor. We will certainly try to coordinate to keep it at the lowest.
All right. So with regards to this motion then, I'm not going to hear it yet. I'll wait till you all have reviewed whatever body cam or whatever statement you're saying your client has made. And then if you all can't come to an agreement, then Mr. Featherston, let the court know before trial that you can't come to an agreement. And both parties can let me know how long the videos are. And then I can make a decision on whether it should be carried with trial, or we can do it probably after jury selection.
Your Honor, we no objection to it running trial.
All right, thank you. All right, the motion in limine. And it says defendants number 1. Is there more than one, or is there only one?
Judge, I've only found this one omnibus motion at this point. And I think it covers really everything that will be involved with this particular trial.
All right, so number 1A. Counsel, what I can tell you is in this court during jury selection, I don't have either defense or state make challenges for cause in front of jurors. What ends up happening at the end of voir dire, I have the state and the defense see if they can agree on people that they deem should be stricken. If you all can't agree, then you come to me. So that will be granted. Any objections to that being granted, state?
No.
All right, B, why a guilty person would plead not guilty and have a trial? I don't think that I've never seen the state do that. At least these prosecutors do that. I'm sure there are some.
I understand that. And I don't really think it will be an issue at trial. But, you know, you never know. You don't know till you know.
State,
Same with me, not. As long as that's
okay,
not wrong.
okay. C, any extraneous conduct or omission that could be regarded as misconduct by the defendant?
It's so general, I don't understand, I sort of.
All right, Mr. Featherston?
Yes, Judge. There are 3 principal witnesses in this case. I think it's probably a fair characterization to say that they don't like Mr. Rios. Throughout the body worn cams, there's discussions of extraneous offenses that they allege that Mr. Rios has committed. And I'm merely asking that I be given, if the state's going to use that I get notice of it, or if I don't get notice, that we approach the bench and have a discussion prior to that being mentioned by a witness.
All right,
That the state would agree.
okay. So any extraneous conduct, and you say extraneous omission,
No, extraneous conduct, Your Honor.
but you have or admission. Omission, I'm sorry. You have either something he did or something he did not do.
Judge, omission for this particular case does not apply.
Okay, so I'll remove that. So any extraneous conduct that could be regarded as misconduct by the defendant, I will say parties are to approach before introducing before the jury. Are both parties agree with that?
Yes, Your Honor.
Yes, Your Honor.
All right, D, asking the court to recognize any defense witness as an expert.
State's comments.
I mean, I know sometimes there's an argument over whether a witness is an expert. And so I'll make a ruling, either the objection is going to be overruled or either it's going to be sustained. So I don't know how the court does that without saying, you know, if the defense says, objection, this person is not an expert in this witness, can I take the witness on voir dire? And you take the witness on voir dire, and then I say, that's overruled. Then I don't know, do you want the state to not say, okay, the judge just declared you an expert, so you can testify to this, or either the judge is allowing you to testify to this?
Principally, Judge, I'm concerned about a emphasis being added to the witness's testimony. I think the proper way, if a state is going to sponsor someone as an expert witness, then I believe that I should be able to determine their credentials outside the presence of the jury. The court make a ruling on that. And then the issue as to expert credentials have already been settled before the jury then hears testimony. Then if the state decides that they want to put on their curriculum vitae or discuss their expertise that establishes them as an expert, at that time, I really don't see any need to object because the court's already made a ruling
Right.
outside the presence of the jury.
Well, Mr. Featherston, the way the court does it is the witness is on the witness stand in front of the jurors, and everybody can ask whatever questions they want to ask. The state can ask their questions to establish the person as an expert. I know that sometimes the state will say, have you testified as an expert before? And I don't think that question is objectionable. And then if you want to take the witness on voir dire, you can.
Okay, all right, Your Honor.
Okay.
Of course, we're going to go with how the state rules on that.
Mhm.
I'd like the court to note the footnotes at the bottom of the page
Mhm.
with respect to this in my concern.
Oh, I see the footnote, but and I don't think the state is going to say, so Judge, are you recognizing this person as an expert? Am I correct in that, Mr. Gerhan?
That's correct. I don't know where this applies to this case necessarily, but I agree with you on.
Okay.
not gonna do that.
So are you in agree to not to number D, asking the court to recognize any state's witness as an expert, not to say, so the judge has recognized you as an expert? I don't.
Not knowing the case, Your Honor, I don't know if the state, I mean, I feel it might be just one of those. I might have to approach, I just don't know the case itself that well, that if we have an expert, that we can bring forward.
All right. So on D, Mr. Featherston, what we'll do is you all approach if there's an expert that is called, because I don't even know.
Nothing more than that.
All right. Thank you. So parties, you're to approach on D if that becomes relevant.
Thank you.
Referring to or describing any statement by the defendant as a confession. That's going to be denied. I mean, it's, the state can, refer to it as a confession. Defense, you can refer to it as a statement. Referring to or describing or mentioning any effort by the defendant to suppress, exclude, redact, or excise anything. Defense, you want to explain that one to the court?
Judge, I'm sorry, I could barely hear you.
Oh, I am so sorry. Referring to, describing, or mentioning any effort by the defendant to suppress, exclude, redact, or excise anything. What is that in relationship to?
Judge, if for instance, we have a hearing outside the presence of the jury about excluding some particular piece of evidence or extraneous evidence, I wouldn't want the state to come back and then refer to the defense trying to hide something from them.
Oh, they're not going to do that. Mr. Gerhan, are you going to do that?
I think that would be partially on the side, I'd be honest, no.
All right.
I will not.
So, because my question about F, Mr. Featherston, was, for example, and this is just a hypothetical, if this were a drug case and an officer or somebody wants to testify that a defendant tried to swallow drugs or tried to hide, drugs in his back pocket, I would think that would be allowed. So when you're referring to describing any effort by the defendant to suppress, exclude, redact, or excise anything? Are you talking about motions to suppress?
Judge, I'm talking about hearings outside the presence of the jury
Ah,
and rulings on those. And
all right. So then F should probably would better state that the defense or the state is not to put before the jury, I guess, rulings made on admission of evidence. Is that what you're asking for?
essentially, Judge, I think that, there's all sorts of ways to get to New York City here. And I think the way you stated it will work.
All right. Any objections to that state?
No, Your Honor.
All right. Professional conduct. All right. State no eye rolling sign or other immature and unprofessional behavior.
Judge, I spoke with Mr. President about this. The state's not in disagreement if both sides are assess these rules of conduct.
Okay, neither party is to do that. Lodging speaking objections. I do, Mr. Featherston, I do not like speaking objections. I like for people to give legal objections. So I'll is that agreed to?
Yes.
Although I know sometimes, Mr. Featherston, the objection that people want to make is not listed, but we'll do agreed. Sidebar remarks.
State's agreed. Obviously, part of the vote.
Okay. Except for the heat in the courtroom, people are able to make objections to that. Maybe we'll get the AC working. Striking at the defendant over the defense, that's agreed to. Community expectations.
I'm sorry.
No, go ahead.
I did speak with Mr. President about this, and I stated that, I guess, verbiage or wording of this, I did argue, I would say that I could argue that for community safety.
Yes.
And concerns that I could argue that. So I guess in a broad spectrum of it, the state is not in agreement with that this portion, but we understand that there's some application through case law.
All right. So are you, Mr. Featherston, do you have any objection if the defense were to argue to the jury public safety issues?
Judge, Mr. Garahan and I extensively talked about this yesterday. His statements to me, his hypotheticals, were all within what the law allows. My community expectations and where Cox is coming from is where that's been exceeded. From my discussion with Mr. Garahan, he well knows what the limitations are.
All right.
And I've known him for a long time. I just don't see him going outside of what he's allowed to do.
All right. So with regards to community expectations, that are you waiving that and we're ruling on it? Because I expect everyone, both sides, to follow the law.
Well, Judge, it's just an in limine. I mean, it's not, we're not setting things in concrete here.
No, because then I know it's in limine defense, but if this, hey, approach beforehand, if this is approaching beforehand and it's closing argument, then that's the state or that's the defense giving each other what your closing argument will be. So if you wanted to make some argument and it fell under these community expectations, then you'd have to approach and the state would have to approach and you'd basically be telling the state what your argument was.
Judge, if the court is viewing it in that light, then I'll go ahead and waive community expectations And if I find it necessary to make an objection during the course of the meeting, I will.
Okay, and both defense and state, I know I don't have to tell you all this because I've seen both of you practice law, but I expect everybody to follow the rules. I expect everybody to be respectful to each other. So I know you all will do that. All right, the next one is personal opinion in vouching for credibility of witnesses or state's case. The prosecutor represents the members of the jury panel of the public. With regards to the jury panel, I can see that, Mr. Featherstone, and with regards to the public, I don't think that part should be there.
Judge, that's my exact statement. I think so, Mr. Featherstone actually made.
I'm okay with that.
Okay, so I'll remove or the public and then it's agreed to.
Yes, sir.
Prosecutor believes that the defendant is guilty. State.
I spoke with Ms. Featherstone about this one too, and I believe that, if I remember right, I look personal. I think personal belief is not appropriate, but I believe that as the state has proven that the defendant is guilty, I think we hashed that out yesterday. So in agreement to my personal belief, I personally believe that this defendant is guilty. I believe that we can argue that the state has proven their case. The only reasonable doubt is this defendant is guilty, and sort of a condition of what possible argument would be.
All right, defense.
Judge, I'm just concerned about unsworn testimony getting in front of the jury. We did discuss this yesterday. The Villalobos case, I believe, is illustrative of this particular issue. But in that particular case, the prosecutor involved in that stated it was obvious that it was a personal, that it was the personal belief of the district attorney and not based upon the evidence that was presented at trial.
All right, so what I will do if there's no objection, I will write the prosecutor personally believes that the defendant is guilty, that they be precluded from saying they personally believe. Any objections to that state?
No, Your Honor.
Any objections to that defense?
No, Your Honor.
The prosecutor is not paid enough to try and convict an innocent person.
Is that we can agree to argue that or?
Well, I know that Bexar County has some of the lowest paid prosecutors, the lowest paid defense attorneys in all of Texas. Even the small counties pay more than Bexar County does. And this is me on my soapbox a little bit. For a county this size with this number of people, you would think that defense attorneys, and I've been a defense attorney, so I know defense attorneys are some of the lowest paid defense attorneys, but great defense attorneys. On the CPS side, those attorneys, which I've been an attorney over there too, lowest paid, and they are supposed to be in charge of protecting children. And prosecutors are the lowest paid here. I know in some counties where third chairs are paid more than second chairs in Bexar County. And we can't get proper AC in this courtroom. So I'm just putting that out there.
But Judge, other than, I appreciate the soapbox,
Yes.
but the state would be agreed as long as it's both sides. Mr. Pettis is not arguing that he hasn't been paid enough to represent a guilty person.
All right, so that's agreed. All right, the prosecutor does not introduce evidence unless she or he believes it's true. That'll be agreed to.
I believe so, and I believe that's making statements.
Prosecutor would not prosecute the defendant unless the state's witnesses were telling the truth that the defendant was guilty. Agreed.
Yes.
Prosecutor has personal knowledge regarding credibility of the witness. Agreed. Prosecutor believes that any particular witness was honest or told the truth. Agreed.
Yes.
Police officers are entitled to greater credibility than a defendant because the defendant has an interest. Is that agreed?
Yes.
Jurors are paying the police officers through their taxes. And because the city has retained the officers on the payroll, that the city must have confidence in their honesty. Agreed? Police officers sworn and told to tell the truth. Is that agreed?
Yes.
Prosecutor not attempt to bolster or rehabilitate the decedent's character. Is it? All right, is that waived?
Your Honor, K or Kilo is waived,
All right, thank you.
and I'll also admit to the court that this particular section is widely discussed when I go to pull out.
Okay. All right, referring to individuals as victim or the words to that effect. State.
Your Honor, I'm not in agreement with that. I understand the premise of it and the argument behind it. But state's not in agreement. If you want me to argue that a little bit more, Your Honor, I will.
Yes, I'll let the defense make their argument and then state you can make your argument. Defense?
Judge, if it please the court, we also have a motion filed concerning that issue, so they're quite interrelated.
Okay, and I'm aware of the law on it.
And Judge, we discussed this in great detail on a different case in front of the court. I know the court remembers that.
Yes.
And it's the exact same motion, and I will rely upon the court.
All right, state.
State would just say that in any case, Your Honor, we're not stating necessarily, we're trying to convict the defendant of the crime that we are accusing him of. And no matter if that conviction happens or not, there is a victim of the crime. Now, whether that defendant is guilty of that crime is the question, and not a question of whether the complainant or what we call the victim is actually a victim. So I believe the state should be allowed to call that person what they are, and that is the victim of a crime.
All right, this is what the court is going to allow. You can refer to the victim. I'm sorry, your witness. You can refer to them as the complainant. And if you want to refer to them as a victim of a crime, you can use the words victim of a crime, but you can't refer to them specifically as you are a victim. Does everyone understand?
Yes.
Any objections to that defense?
No, Your Honor.
Okay. All right, so I'm writing in the state and or defense may refer to the witness as a complainant or the victim of a crime. Derogatory references to the defendant, that will be agreed. Am I correct?
Yes.
Election of defendant not to testify. Of course, states you're not allowed to make a comment on the defendant's election not to testify. No, you know. State cannot call the defendant as a witness or otherwise compel testimony. Is that agreed?
Agreed, but I did mention this first during board order. I do cover that about the record remaining silent amendment, and I do sort of flesh that out. So I just want to make sure this was not all encompassing that I can't talk about it. Obviously, during board order about why explain that the defendant doesn't have to take that stand. You don't use it against. So I would be explaining it and touching on the subject.
And Mr. Featherson, I talk about that as well. Are you just speaking during the trial?
Judge.
And I'm assuming during trial and closing arguments, if your client decided not to testify.
That's correct. That's correct, Your Honor.
So I'm going to add during trial and or closing arguments. So is that agreed?
Yes, Your Honor.
And of course, that will carry through. If it becomes to punishment, of course, that will be the court. So I will ignore that if someone wants to bring that up. The motive for the offense has not been revealed or is locked up. What, Mr. Featherston, can you explain that one to the court?
Judges, in this particular case, the Kohler case, that's what the district attorney referred to, and it turned out to be a reversible error.
No, I mean, the motive of the offense has not been revealed. Are you saying that the state is somehow commenting on your client's right to remain silent if they're saying like only he can reveal the motive, or that's what I'm trying to understand.
It could, I think it could be extended to that, Your Honor. That particular in Kohler, I don't really think it was verbalized in that particular manner.
Mhm.
It's very narrow. I don't anticipate that the state would bring it up. Mr. Garahan is a very smart attorney. I mean, this took place back in 1975.
Okay.
And I haven't really seen anybody use it here.
All right, state.
It's not come out.
I believe, I talked to Mr. Featherston about this yesterday, and I think if we're alluding to the defense to remain silent, I think the state isn't thinking on that we will not allude to, and it's, I believe, locked up the motive. I mean, if we're trying to prove motive through other individuals, other sources, that's where I believe that state would be able to venture into.
All right, so what I'll add then, Mr. Featherston, is if it alludes to the defendant's right to remain silent. Do you have any objection to that being added?
Objection, Your Honor.
All right, then that will be agreed to. Not being contested that the defendant committed the offense. I've seen the state usually say, Mr. Featherston, it's not contested that this happened in Bexar County, or it's not contested that whatever happened on this date. But C, any objections, state?
No, I think this sort of hits on the same, allude to, defendant's right to remain silent, and the state will not be doing that.
Okay. D, there has been no explanation for the offense.
I'm sorry to reiterate, but it seems like, again, that, I think there's, again, I don't know, it's up to me to the station owner, but there's times that we explain to a jury that there's no explanation for an offense to happen at times. You don't know the motive. If it's alluding to the defendant's right to remain silent, again, the state's in agreement with that portion.
All right. I'm going to add if alludes to defendant's rights to remain silent. Any objection, Mr. Featherston?
No, Judge, and both the Meyer and I think the Lee case were, there's a difference between verbal and nonverbal communication. And you can not say something, but use your body language to indicate something. So in those particular two cases, if I remember correctly, the prosecutors were pointing to the defendant at the time that they made their statements.
Okay. All right. And then E, I'm assuming that's agreed to.
Yes, Your Honor, that is.
F, rhetorical questions of defense counsel or the defendant.
I'm agree with that.
The prosecutor not asked, G, the prosecutor not asked rhetorical questions of the defendant under the guise of argument.
I agree with that.
Prosecutor not referred to the defendant's failure to raise any particular defense. Is that agreed to?
Yes, Your Honor.
Defendant has not apologized or expressed remorse.
I mean, I believe that might be something that if the defendant made a statement in this particular case, that's something that the state can agree to and approach if we feel that it may come out wrong.
All right, then what I'll do on that one, Mr. Featherston, and I'll just ask the parties to approach if anybody's going to talk about your client not apologizing or not having remorse.
Thank you, Water, and I think the court should also know that the cases that I cite in that paragraph, I believe they're all guilt innocence cases,
Okay. Okay. All right. So everybody just approach. Improper reasons to convict. All right. Rising cost of crime. A, any objections, state?
Other than safety concerns.
Okay. B, agreed to.
I was a little confused on that one, but I mean, I can say can agree to that, as if, unless you're included, is included in the charge ones.
Okay. The jury would have to disregard every honorable thought it could ever have to acquit the defendant. Agreed. Agreed to D.
Yes, Your Honor.
E, agreed.
Yes.
F, agreed.
Yes, Your Honor.
All right, criticisms of defense counsel. All right, A, you're not going to say that Mr. Featherston is the mouthpiece for criminals, are you?
I'm not, yeah, I agree.
All right.
But Judge, he can call me the worst attorney in Texas.
He will not do that either. Because it wouldn't be true. Prosecutor is grateful that she represents of the people of the community and not make a living representing criminals. Agreed?
Yes, Your Honor.
Prosecutor took an oath to seek justice, but defense counsel did not. Agreed?
Agreed.
Defense counsel's duty is to get the defendant acquitted, even if counsel has to put on witnesses to lie. Agreed? Assuming the defendant is guilty, whether defense counsel wants the truth before the jury.
Agreed.
References to any other criminal cases handled by defense counsel. Agreed?
Yes.
Defense counsel has manufactured evidence. Agreed? And when I say agreed, not that he has done it, but you won't try to say that he's manufactured evidence. All right. Defense counsel and the defendant lied in entering a plea of not guilty. Agreed? Defense counsel was willingly to or did lie to the jury. Agreed? Defense counsel did not argue that the defendant was innocent. Agreed? Defense counsel intimidated witnesses, the court or the prosecutor. Is that agreed?
Yes.
I'm going to remove the court out of that, Mr. Featherston. I cannot be intimidated. Okay, number one.
I agree with that.
References to defense counsel's strategy, courtroom tactics, or ethics, such as suggesting the counsel is shrewd or tricky. Agreed?
Yes, Your Honor.
References to defense counsel making objections during trial. Is that agreed?
Yes, Your Honor, that was just another thing I thought was supposed to, that here at Board at times I do mention about objections to defense for state and sort of hash that out just to explain that the jury, that happens during jury trials. And I believe that sometimes
Yes.
you do too. So
Yes.
I just want to make sure that was allowed.
All right.
You are a good piece of court. During board hour, I do discuss objections and say no harm, no foul
Okay.
about that. So I know it is discussed amongst, the three of them.
Okay. References to defense attorneys, long as lawyers are for hire, justices for sale. Agreed?
Yes.
Court proceedings. Prosecutor may not comment on rulings of the court or the defendant's non-testimonial demeanor in the court. State could not introduce certain evidence due to the defendant's objection. Agreed?
Yes.
Court heard the same testimony as the jury and found the evidence admissible. Agreed? Court's inclusion in the jury charge of the defensive theory or lesser included offense does not mean that the court believes it. Agreed?
Yes.
References to the defendant's non-testimonial demeanor in the courtroom.
And Your Honor, just to touch on that, I mean, I believe at times that there's an outburst or there's action by the defendant as possibly intimidation factors at times. It is a difference.
All right. And I'm assuming this would be as it relates to closing arguments, Mr. Featherston?
Certainly applies in closing arguments, Your Honor. The nonverbal communication throughout the trial is self-evident.
All right. So parties on that, I'm going to have you approach. If you see something, or Mr. Featherston, or if you and state if there's something that you want to get into that relates to Mr. Rios's demeanor or something else that has happened, approach first.
Judge, be glad to do that. I think really for me, the only time it comes into play is when I see a sleeping juror.
Okay. All right. And then that the defendant could elect whether the court or the jury assess punishment. I'm going to deny that one. Well, you're saying that the state is not to bring that up, but I can tell you during voir dire, I always let the jury know that the defendant has to make an election to punishment. And that's not saying that he's guilty. It's just that the law requires him to make an election. And I always ask the jury if they hold that against him. Is that what you're referring to? Or you're referring to the state saying something like, look at him going to the judge for punishment? What is that referring to?
Judge, I think your explanation was quite adequate about that and the discussion of it at the voir dire, and the law does require an election.
Mhm.
When I first drafted this a while back, I was thinking of, well, he's gonna get lesser punishment if he goes to the judge. And that type of an argument.
Oh, is that what people say?
Say again, Judge?
Is that what people say?
Well, some folks will say that that judges will punish more lightly than juries. But it really depends upon the type of the case, and it's a very complicated issue. And I quite frankly, I've really never had a prosecutor say that, based upon his election, he's looking for lesser punishment.
All right. So are you waiving E? Because I cover E during voir dire. The state doesn't cover E during voir dire. I've never heard the state, at least the prosecutors in this court, talk about the defendant's election for punishment.
Well, Your Honor, we talked about it, so I think I'll go ahead and waive E
Okay.
as far as it being an immunity issue.
All right. And then arguing contrary to the court's charge. A, any statement of the law that is not contained in or in contrary to the court's charge. State. B, evidence submitted for a limited purpose can be considered for any other purpose. I mean, that's against the law. And I can tell you, I put in the court's charge a limiting instruction if there was an extraneous or other evidence that's admitted that is for a specific purpose, that's in the charge. So is that agreed to, state? C, jurors must unanimously agree that the defendant was not guilty of the offense charged before they can consider any lesser included offenses. Well, C, I think if they're lesser included, they first make a determination whether somebody is guilty or not guilty of the charge. And then if they determine that they're not guilty, then they go to the lesser included.
That's the state's position.
All right. So, and that's what's, Mr. Featherston, is that an issue with the argument if the state were to say in their closing arguments?
Well, it goes back to the unanimity of the jury panel in deciding which direction that they're going to go. There's been a lot of case law on that. Mostly it's sex cases concerning that. I'd still like to be able to have this particular indemnity granted.
But I believe, Mr. Featherston, I believe the law is if the charge is aggravated robbery and a lesser included offense, and this is just a hypothetical, if it's an aggravated robbery is what someone's charged with, and then they get a lesser included offense of robbery, then the jury has to make a determination of whether they find them guilty or not guilty of the aggravated robbery. If they find them guilty of the aggravated robbery, then they don't go to robbery.
I agree with the court's statement on that. And, Judge, maybe we're just better off dealing with C at the charge conference.
Okay.
So if the court will allow, I'll go ahead and abandon C at this time.
Okay. Okay, and then we've already addressed your motion about referring to the witnesses as complainant and as victim. Do you waive this motion since we've already heard it internally in another motion?
Judge, I didn't quite hear which motion. Were you talking about the victim motion?
Yes.
Yes, Judge, you've already ruled the victim motion. And, Judge, are you in receipt of my 21-page addendum to the interview?
Oh, that's a joke. Okay. I was like, what? Oh, my gosh. All right. Are there any other motions?
No, Your Honor, everything else is the letter notice to the state, and the state, I'm sure, will address those issues. I don't see a need to bring them in front of the court at this time.
All right. Is there anything else that we need to take up?
I'm gonna say,
My increased pay schedule.
Yeah, I tell you, I am working on all of that diligently. You know, I was a part of a, I don't know if you remember, Mr. Featherson, probably about, I don't know, 10 years ago or 12 years ago, there was a committee put together to see about raising the pay of defense counsels.
I do remember that, Your Honor.
Yes. And so I was on the committee and I was fighting to get pay raises. I did all this research on every county in Texas, and we are truly the lowest paid county for prosecutors and for defense attorneys in Texas. And I presented that to all of them. And did I get paid to be on the committee? No, but I did it because I'm like, I'm fighting, for people to get better pay. It didn't happen, but I tried. So that's
I
what,
think all that research that you did back then is still applicable today.
yes. All right. So Mr. Featherston, we will have you here at 1:30. Yes.
It's in 1:30.
All right. Thank you. And if you still need to speak to your client, of course you can. Yes. Yes. Sure. Okay. No problem. All right. Can you call John Winter, Bridget Garza? Oh, hey, I didn't see you. Hi. And Anthony Cantrell.
Will be selected to both sides will have almost now.
All right. And then Miss Tibbs, you have motions as well? All right, just give us a moment. The court reporter is taking a short break. And then we'll take that up.
Okay, all right.
Who has Rihanna Macias? There's some matter that's off docket.
Yes, for tomorrow.
Yes.
I conferred a couple minutes ago. I have letters of support for her, and she's finishing her outpatient treatment. And I wanted to know if I could reset that from tomorrow to just another 30-day reset, just have her finish a couple things. To convince the state that they needed the right thing. And
State always does the right thing.
this one's gonna need a little bit more convincing, Judge. But I thought I had it right here. No, she's working on her outpatient DWI education classes, things like that. I was asking for a little bit more time for her.
All right.
And
What,
for the state, for the maybe 12 letters of support.
all right. So what time, how much time are you asking for?
30 days should be fine, less, more, doesn't matter.
No objection to the state judge.
Okay.
I think I get bonus points for having it.
Well, also thank you for telling me how the number just because I can't count.
You'll be able to do that when I give it to you.
You found me, you found me out.
Is it, you can't?
Ms. Ferguson, on Rihanna Macias, can I have a 30-day reset?
11, 13, 14.
Yeah, weirdly 12 is the one which is
All right, it's reset for April 17th. You need to let your client know.
also judge.
Yes.
That band is amazing.
Oh, yes,
Feels so much better.
it does. Who did the fan?
April, so was it 17 or 19?
Oh, gosh, the fan does feel great.
Yeah, no,
Thank you, Judge.
I came up here and I was like, oh my God, this is such a big difference.
It is. We're gonna have to keep that. Hopefully no one takes the fan.
Okay. Do you want it? Okay.
That's what we're doing. So. Well, I talked to the prosecutor. This is usually the family file. That's the criminal code. Your case is. The aggravated assault of the other case because it's still a connection. It's a criminal code. Because this case with your sister, that's a family file. So, I've already had some discussions with the family file. And are they reason to do? But it's something like dismissal. This is dismissed, the bonds no longer applies, the bond times already on the bond. So they should process you be released. And then the do notify, then we'll meet at the office or here or at the you're gonna go in that and pay until now. It's okay. It's okay. I've asked the other attorney, the more I feel it really being hard is work on this, working this. And you talk about communication. What's been done it's how the person
Who's here on the motion for continuance? Can you let defense counsel know that needs to be notarized? The motion for continuance, I believe it's Tracy Franklin. Can you let her know that needs to be notarized?
So you just that number one for the and so and more.
Oh, no problem.
Don't expect real eye contact with the phone, so. Nervous about that.
No, your client is.
You have somebody who locks eyes with you though.
All right, and Miss Tibbs, after this case, I'm going to take up your matter. After this case, I'm going to take up your matter. All right, the court is calling 2022 CR 8089, State of Texas versus Christopher James Edwards. Could I have the parties approach and announce for the record, please?
Daniel Spark, State of Texas.
Richard Gossa for defense.
And are you Mr. Edwards?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client?
I have your honor.
Court will find that the state is in compliance with discovery. Mr. Edwards, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, your honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Edwards, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of criminal mischief to $2,500 to $30,000 as a state jail felony? The range of punishment for that offense is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, your honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes,
Do you believe he's currently competent and was legally sane at the time of the offense?
yes,
Mr. Edwards, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 57 days in the Bexar County Jail under 12.44 of the Penal Code, and there's no application. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
yes,
State?
Yes, Judge.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there been any such motions? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence?
State offers states exhibit 1 and all attachments.
no objection.
Mr. Edwards, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations, and state you can continue to confer. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
I do, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. So with regards to this restitution. I mean, they're saying in here there's restitution of an estimate of $5,000.
Yes, Judge, but there's a restitution that was submitted. 3,300. It should be attached.
Okay,
There was a receipt attached to it.
all right, so has the restitution been paid?
No, Your Honor.
I mean, if y'all want to go forward with this agreement, he's going to have to pay the restitution. I'm going to put that as a part of the judgment. So do you want to discuss that with your client? And it appears that this restitution is not from the bus. This is the restitution from the vehicle that you were in. Counsel, does he wish to proceed?
Yes, Your Honor.
All right, the court will find you guilty. Sentence you to 57 days in the Bexar County Jail under 1244 of the Penal Code. There's to be restitution of $3,333 to Via Metropolitan Transit located at 800 West Myrtle, MYRTL, San Antonio, Texas, 78212. Is there anything else from either side with regards to sentencing?
I think that's
And I'm sorry, and I'll give you credit for any time served. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you. You're going to have to behave better. You understand? Otherwise, you're going to be in and out of custody. And we're off the record. I read the police report. And if you would have just accepted your citation, which is a ticket, gone about your way, you could have handled this in misdemeanor court or municipal court. But since you didn't, now you have a felony conviction and you have $3,000 that you owe. And they're going to come for that $3,000. You understand?
Yes, Your Honor.
All right, good luck to you.
Thank you.
Yes. Sure. Hi.
This one. This one.
I love the nails.
Oh, thank you. They were fun.
Here are.
Show Mama Boyd also.
Yes, there you go. Mama Boy always likes seeing you.
Aw, tell her hi for me.
I will.
Stop touching.
All right, can I see the file on Caleb Coleman? And Norma, where's Mr. Cantrell? No, he hasn't. You know what, call Mac. Is this a case that he's retained on? And everyone, I'm going to take a 5-minute break and then we'll take up your matter. Mr. Winter, are you ready?
Sure.
All right, I'm sorry. Could I see the file on Vanessa Varela? Is this a bond?
We're in agreement on it.
Apparently, what Norma tells me is that the prior attorney, there was a court appointed attorney.
Yes.
Who filed a suggestion of competency on it.
Mhm.
And so, I don't think that this is gonna get in the way of that. And so I was just talking to her to see if, I can tell, based on my experience and knowledge of competency and everything. And I couldn't tell. So I'm fine with her being evaluated, but I don't want it to slow her down as far as if she's able to get out, if she's able to go home, stay with her family. I think that'd be best for her.
All right, just give me 3 minutes now. I need to make a quick phone call.
Yes, sir.
Okay, Joe. Yeah.
This is on today.
Okay, Norma, on this one, she needs to get that notarized. The motion for continuance.
Oh, I think she makes a copy, Judge.
Okay,
That, wait, no. This is the. Was that Renee's? Yeah. Renee. Just here.
all right. Ms. Tibbs, I keep saying you're next, but should be a quick matter.
Okay.
If y'all can come forward on Vanessa Varela. Come on. Yes, she's in the middle. All right, the court is calling 2023 CR 1180 State of Texas versus Vanessa Varela. Could I have parties announced for the record for the state,
Jason Garahan, Your Honor.
for the defense?
John Winter for the defendant.
And are you Vanessa Varela? You're gonna have to answer yes or no.
Vanessa Varela?
Yes, is that you?
Yes.
All right. And I'm sorry, state, do you have a copy of a police report on this?
I don't, but I can,
If you could print one up for me?
yes.
All right, and while the state is printing that for me to review, I understand that you all have an agreement on a bond amount, but I need to review the police report to see if the court feels it's appropriate.
Okay.
The next thing I want to address is there was a motion for competency examination file, and Mr. Winter, as you know, once it's filed, it needs to be addressed.
Sure.
So there are some questions that I need to ask your client with regards to the competency motion so that I can make appropriate conditions of bond if I agree to this bonded out amount. Ms. Varela, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hands. All right, Ms. Varela, I'm not going to ask you anything about the facts of the case. I'll read the police report in regards to that, Mr. Winter. Your previous attorney had filed a motion for a competency. Have you ever been seen by a psychiatrist or a psychologist? You're gonna have to answer.
You have to say it out loud.
No,
Have you ever been diagnosed with any mental health issues?
no,
Has anyone in your family ever had any mental health issues?
no.
Do you have a place to live if you were released?
Yes.
Who would you be living with?
My mom?
Have you spoken to your mother and asked if you can live with her?
No.
So where were you living when this alleged incident happened? Were you living with your mom or were you living by yourself?
With my mom?
And Mr. Winter, do you know whether or not what she's charged with is alleged to have occurred at the home with her mother?
It's not, Judge.
Okay.
My understanding is it's alleged to have occurred at a neighborhood house, but it's not at her mother's house. Her mother is the one who came and hired me, and I'm sure that she'll be okay with her being back in the house.
All right. Do you have any children?
Yes.
How many?
2,
What are their ages?
3 and
3 and 4?
3 and 1.
3 and 1. Okay. Do they live with you?
Yes.
Have you ever used any type of drugs?
Mm,
You need to say yes or no.
yes.
You have?
I'm sorry.
Have you ever used any type of drugs? Have you used marijuana before?
Oh, yes.
When was the last time you used marijuana?
Like a month ago.
Have you ever used cocaine?
Yes.
When's the last time you used cocaine?
Like a year ago.
Have you ever used methamphetamine?
No.
Have you ever used crack cocaine?
No.
Have you ever used alcohol?
Yes.
When's the last time you used alcohol?
A month ago.
How often do you use alcohol?
Not a lot.
What does that mean?
Like somehow, sorry.
I don't drink.
Well, how often do you drink alcohol?
Here and there.
I mean, is it once a week? Is it twice a week? Is it once every 2 weeks? How often?
Once every 2 weeks.
And how often did you use cocaine when you were using?
The same.
How often are you using marijuana?
Almost every day.
Sorry, Judge, I just
Oh, no
trying to
problem.
make sure it's.
Any objections to the court reading police report?
No, you're.
All right, and Ms. Varela, I'm reading the police report to make conditions of bond for you. I don't accept it as true, but this is me trying to figure out what would be appropriate bond conditions for you, okay? Okay. State. All right, and all right, anything you would like to say? Defense?
Well, Judge, as you know, I spoke with state about the case. We agreed to a reduction on this case to $50,000. If you're willing to go a little lower than that, of course, that would be appreciated. The family is of limited means, and so and any savings that they could make in getting Vanessa back home would be appreciated by them.
All right. If I reduce the bond, then I'm going to require her to be on GPS.
Okay, we're asking if you do require that to waive any fees, since she does have children to feed. She was working at Dairy Queen, but I don't think she makes a whole lot of money.
State, any objection to reducing the bond with GPS?
No.
All right, this is what the court is going to do. Court will set your bond at $20,000. No unsupervised contact with minors, partial GPS, waive GPS fees. Defendant is allowed to work and attend all classes and or medical appointments. I'm going to want, she needs to do sober meetings. She's using marijuana every day, counsel. And I read in the police report that it appears that maybe she was high on drugs or something at the time. She stated in the police report that she didn't know. So I'm gonna want sober meetings. 90 in 90 days. I'm going to ask for random UAs. And we'll do a referral to Center for Healthcare Services. I don't know if she has mental health issues or if there is just a drug issue and the drugs are doing something to her mental faculties. So we're going to do a referral for Center for Healthcare Services. And I'm going to want field visits by the team once per month. And we have to do random UAs, tests for alcohol. And outpatient treatment. That'll be outpatient treatment for drug use. Ms. Ferguson, can you get a someone from pretrial services? I know this is an indicted case, but maybe pretrial services can help her with getting these done as a condition of her bond. Yes, see if you can have someone zoom in. All right, Mr. Winters, I'm going to see if we can have someone from pretrial services zoom in so that you all will have their contact information and that they can help her with any issues she may have. So if you don't mind just waiting around a minute to see when they zoom in,
Sure, Judge.
and I'll take that up as soon as they zoom in.
Okay, Judge.
Caroline, can you make a copy of this for John? And then I'm still going to need the file later. Okay. And there's already a date for that, for. Okay, thanks.
Jurors are outside, Your Honor.
All right, tell them, have them wait a little bit. Norma, I'm sending you the link now. All right, and Ms. Tibbs, on Coleman Lee, how many motions do you have?
I just had two,
Oh.
but there's several different parts.
All right, which two are they? Because I just have one. I have defendant's objection to evidence. Okay,
Yeah, we found back in December with request for production pursuant to RS 39.14.
all right, that has already been ruled on, correct?
No, we had started ruling. The court started making ruling, but because we had the access medical records.
Okay.
We were favored and said we didn't bring them.
Okay, all right. All right, and then Ms. Tibbs, as soon as the court reporter comes back, she has an issue with one of her children at school. So as soon as she comes back, we'll take this up. Okay. You know, see, that's the sign that the emails here are so slow, right? Mhm. Who is here for the discovery? All right, Karen. Okay. Hello.
Morning.
Good morning. So is your client on bond or in custody?
I'm bond, Your Honor. He's right back here.
Oh, come up. Mr. Elizondo, thanks for dressing appropriately for court. All right, so my understanding that this is recalled for today for discovery.
Yes, Your Honor.
All right, so is there any outstanding discovery?
We just, through a conversation with the complainant, as we learned that CPS was involved and there may be outstanding child safety reviews. So we're just requesting more time to get those. I'm in touch with the detective to get those videos over to this court.
All right, so there are CPS records that are needed. And child safe.
Yes. Yes.
And you all don't have the CPS records in your custody?
Not at this time.
Okay. So when do you think you'll have that?
We've sent out a request for them, Judge. At this point, I'm not sure on the timetable. I know that the child safe we should have as soon as the detective confirms that those videos are still with child safe.
Okay. All right. So what I'll do is I'll give you all a 30-day reset, and Ms. Corby, if you all have it before then and you want to come back before then, just ask Ms. Ferguson to put it on the docket and we'll take up the next phase in the process.
Thank you, Your Honor.
All right, Ms. Ferguson, I need a 30-day reset.
April 17th.
All right, so we'll be back on April 17th.
Okay.
Thank you, Your Honor.
May we be excused?
Ms. Ferguson will give you a reset form, then you're excused. Is everything okay?
Yes.
Mhm. Yeah. You can't cover for him because they'll think you did something. That'll be the news. That'll be the news story. Yes, I found it. All right, are the parties ready on Caleb Coleman?
Yes.
Okay, all right. And we may end up taking a short intermission because I'm waiting for a pretrial officer to zoom in, so just know that. All right, court is calling 2022 CR 2393, State of Texas versus Caleb Coleman Lee. Could I have parties announced for the record for the state? Defense?
Eugene Hernandez for Caleb Coleman.
All right, and are you Caleb Coleman Lee?
Yes, ma'am, I am. Yes, ma'am, I am.
All right, thank you. All right, so defense has motions, so we're going to go over those motions. And as I said, off the record, we may have to take a short break once the pretrial services officer zooms in.
Before we start, ask to turn the fan down and it's barely.
Sure. But with the turning down of the fan, what I will tell you is it's probably going to get 90 degrees in here. So.
I'm gonna go quick.
All right. Let's start with the request for production. State, are you in receipt of the request for production pursuant to Article 3914?
Yes, Your Honor, and I believe it may be easier to go based on the proposed order. It looks like some of the numbered paragraphs from the motion from the request don't track to the order, so the report's convenience may be easier to go based on the order rather than requesting the actual file.
All right, any objections to us proceeding with the order, defense?
No.
All right,
So Judge.
just one second. So the first thing we have is a list of names and addresses of all prosecution witnesses, including rebuttal witnesses who are reasonably expected to testify at any stage of trial. Any objection?
Judge, that order is moved at this point because we've already filed our notice, but there's no objection.
All right, that will be granted. Any statements or reports, including any medical or billing records? Records used to provide evidence of existence, causation, or extent and duration of any bodily injury of the complaining witness made by prospective prosecution witnesses which are in the possession, custody, or control of the state or any its agencies. Any objection?
Okay.
Defendant has requested the alleged bodily injury medical records for examination by the defendant's expert as to existence, causation, extent, and duration of any bodily injury of the complaining witness.
Judge, we object in part. We would ask for a qualification that it be limited to documents in the possession of the state. Obviously, if the expert, if any, brings documents or relies on any documents, they would be entitled to that. But at this point, anything that a potential expert would rely on would be limited to considering the state possession.
But if it's going to be medical records, then the defense would need to know that beforehand. Isn't this case, and I only know this because both the state and the defense have had discussions about discovery off the record. So if you're going to call a witness that is going to be using medical records for their testimony, and the whole crux of this case appears to be about injuries or no injuries, shouldn't defense have that beforehand and it not be a surprise as to what the witnesses is testifying to?
Okay. I mean, the defense has been provided with medical records that the state has received. And I know the court knows generally that there may be other records that the defense is interested in. Those are not currently in the possession of the state. Obviously, if they enter into the state's possession, we would tender them to the defense as soon as we get them. And if our expert is, if we have an expert, if our expert is relying on, the defense would be entitled to that. But as far as this order goes, we can only turn over what's in the possession.
All right. So I want both sides to know if there's going to be an expert or some witness testifying about medical records that the defense has not had access before trial, that witness may not be testifying about medical records.
Okay.
And Judge, on that particular issue as well, we were going back and forth for a period of about 6 months requesting medical records. They did subpoena some medical records. They presented those and downloaded those in discovery. But those medical records are unreliable and not probative at all. They were 685 and irrelevant. They were 685 days after the particular incident that she submitted. So in regard to that, we would object to them trying to present those at the time of trial because they were not related to the request for medical records that we initially requested through this disclosure.
But we object to that line of argument outside of the scope of the motion.
All right. Well, with regards to your issue with the medical records that were tendered to you, we can have that be heard either if you have it in another motion or either we can have it heard outside the presence of the jury. But I want parties to be clear. If there are some new medical records, whether it's in the possession of the state or not, that this whole case, the crux of it is being relied upon to prove or disprove something, And the defense is going to be given that, and if a witness testifies or during trial or a day before trial, the court will hear whatever motions the defense has to not allow that evidence be presented. All right, so with regards to bodily injury medical records for examination, as to the existence, okay, with regards to that, it will be granted if it's in the state's possession. Defense, the state can't give it to you if it's not in their possession. Any objections, defense?
No objection.
All right, and then the next one where this defense is asking that the court, I'm assuming, not allow medical records that have not currently been produced. Is that correct, defense?
Again, Judge, I'm sorry.
Your next paragraph, are you asking that the court not allow medical records that have not been produced to the defense? Is that what you're asking? All right. So with regards to that, as the court stated, the court will take that issue up at trial if it comes to that, and that will be done outside the presence of the jury.
Thank you.
So with regards to that, state, if you have a witness who's going to testify and they have medical records, before that person even gets on the witness stand and the state says, did you bring medical records with you? Before it even gets to that point, we need to have a hearing outside the presence of the jury. And then the court can see what those medical records are related to.
And additionally, Your Honor, if he has any expert or someone coming in testifying after they've relied on medical records that I have not seen, I would like that issue taken up before the court as well, outside the
Right.
presence of the jury.
Yes, that will be done. Any
And
criminal?
with regard to any records, because I noticed on their witness list, they're saying for expert witnesses for fingerprints.
All right, the next thing on the list is any criminal record, including indictments, convictions, or pending charges against any witness or possible witness. State.
Judge, the defense and I conferred about that yesterday. I think we clarified that they're basically just requesting criminal histories like a TCIC, NCI search for our lay witnesses. We haven't run those at this point. We do intend to run those before trial, and of course, we would tender them to the defense. We would make them available to the defense. We can't turn them over, but the defense would have the opportunity to review them before trial.
All right, so that'll be granted. You'll be given access to those. And if you need them for cross-examination, you'll be able to use it for cross. Transcripts from the grand jury relevant to the indictment of the defendant. Are there any transcripts?
Not as far as I know, Judge, the state would argue that this request is moot, but we have no objection to that.
All right, that'll be granted. So if there are transcripts, then counsel, you'll be given that. Any and all exculpatory and impeachment or mitigating documents.
Okay.
All right, that will be granted. The next one we have is defendant's objection to evidence pursuant to Rule 103A1.
Judge, on that is a typo. It should be 103B.
Okay.
So Judge, I guess as a point of clarification, this entire, I don't even know if it's a motion, but this entire objections pursuant to evidence Rule 103B or A1 of the title. It's framed as essentially preemptory objections to evidence admitted at trial. Some parts of the motion seem to be motions in limine, and some parts seem to be motions to suppress. If the defense is asserting that they're raising objections pre-trial under Rule 103, the state would argue that these issues are not right at this time. You can't object to evidence before it's actually.
Excuse me, just one moment. Oh, we're off the record. Mr. Winter, can you and your client come forward, please? Ms. Castro?
Yes, Judge.
Hi, I have a case here. It is an arson case. And I've just granted a bond reduction, but she's going to need treatment. Can I give you the case number and can you tell me if you're able to provide the resources that are needed?
Yes.
It's cause number 2023 CR 1180.
2023 CR
1180.
Let me see. Do you have the defendant's name by chance?
Yes, it's Vanessa Varela. I just put it in the chat for you.
Let me see. So for her bond reduction, did she have conditions of the special needs unit?
That's what I want her to have because I'm ordering for the Center for Healthcare Services.
Okay.
I'm putting in the chat box what I've ordered.
Okay, let me see. Because the Center for Healthcare Services is getting very strict on who we're sending over there. So we have to have the condition of bond on there in order to do a referral directly to them.
Okay. You want me to put the word special needs?
It should say special needs unit on the condition form.
See, we don't have the form because it's indicted.
Mm-hmm.
And I'll put down special needs. And I want the random UAs, but I also want included in that a test for alcohol.
Okay. It could be a drug and alcohol test, random drug and alcohol test, and it should. Well, if you want us to test for alcohol, in the office, they do a breathalyzer, however, it's at that time. But if you want a test that's going to show a little bit more, it would be the ETG testing with Century. They test for alcohol, and I believe it's a couple days.
Okay. All right, I just sent it to you. And I'll add on here special needs.
Yes, you put it on there. Plus special needs refer to, you can put special needs unit and then refer to CHDS. Yes.
All right, and I've added in my order special needs unit.
And then they can be referred to the center from there. We'll be able to try to get them into one of the programs.
All right, and could I have your number if you can put it in the chat so I can give it to the defense counsel?
So it looks like he's getting partial GPS. I don't monitor GPS.
Okay.
It would be one of the officers. There's 4 officers that monitor special needs unit out of GPS.
All right, well, can I give him your number and then you all can confer about who he needs to speak to? Because she's in custody and I don't want her to leave the jail and not
She
know.
won't. She would have to meet criteria to get released on the GPS.
Okay, all right.
I can
And
give
what-
you the phone number for the officer who does the criteria,
Sure.
or I can give that to the defense counsel.
All right, if you will give it to me and I'll make sure he gets it.
Yes, let me get that for you.
And Mr. Winter, if she does well, I'm just trying to make sure she's stabilized when she leaves. So if she's stabilized, then you can always come back for removal of GPS.
Sure, Judge, that's understood.
I don't even have the chat up to look at the number. Sorry.
What's that, Judge?
I said I didn't have the chat box open for me to see the number. But Ms. Varela, I'm not trying to make conditions as punishment, but I'm doing it so hopefully you will be successful on bond and we won't see you back here again.
Let me get that. Trying to find it. It's gonna be,
Okay.
that doesn't look right.
And what is happening with Anthony Cantrell's client? Hi.
He wanted to confer with me, Judge, but.
Oh, no, go ahead and confirm. Yes, yes, we're good.
It's 33210-335-8962.
8962.
Yes.
And what's the officer's name?
It should be Officer Avalos or it's somebody covering the DO, because those are the GPS officers who work on release.
All
On
right,
getting
thank you.
defendants out on release to meet criteria.
Thank you so much.
Mhm.
All right, thank you.
Thanks, Judge.
Have a great rest of your day, even though it's like London weather here with the fog or rain, whatever it's trying to do.
Yeah, and super hot.
And John,
Yes, sir.
I had to write new things in there about special needs.
Oh,
Yes.
Okay, thanks.
Thank you, Judge. May I be excused?
Yes, thank you so much.
You're welcome.
I'll see you in the back.
All right, we're going to go back on the record on 2022 CR 2393 and defense. I believe the state was answering your objection to evidence pursuant to rule, and you said it should be 103B. All right.
I mean, the same position is basically that if this document is what it purports to be, which is essentially objections in advance of the presentation of evidence, the state is arguing that this entire motion is moot, and, or I'm sorry, not unright at this point. If it is more of a motion in limine, which individual paragraphs appear to be like limine or suppression issues, then we can address that. But if the defense is only attempting to preserve error, which is the purpose of 103B, then we're arguing that it's not right at this time because no evidence has actually been presented in trial.
All right, let's go to part two. Part two appears to be,
Judge, I have, if I may, and I know
yes,
it's a little bit out of order, but I wanted to step back a little bit on the prior motion just for a point of clarification.
mhm.
I did receive a list of witnesses, from defense counsel in my request for disclosures. And, in this list of, disclosures of witnesses, it states several different people that are fingerprint examiners. And when we look through our discovery, we do not receive any reports or any information regarding any fingerprint examiner. We did see where one police officer attempted to try to get fingerprints. And was stated that there were no prints available. So, this concerns me at this late date that there's a fingerprint examiner coming in to testify because that was not previously submitted to us in discovery.
All right, state, what is with the fingerprint examiner?
Judge, it's a little misleading to say that this is late. We filed our notice of witness list back in February 27th, 2023. The fingerprint examiners that are listed in the state's notice are fingerprint examiners employed by Garrett County. They're used for the purposes of proving up prior arrest or conviction. The defense is correct in that there was no fingerprint examiner related to this case in terms of any investigation done by the law enforcement agency, at least to my knowledge. These are fingerprint examiners that we would bring in if we had to prove up other arrests or convictions if they become relevant at trial.
All right, so my understanding from what the state is saying is that if your client were to have been sentenced on another case, then in order to prove up the judgments or whatever they want to prove up, they would be requesting that he be fingerprinted in court. So my understanding, the fingerprint examiner is not necessarily for the instant case here. It's for if he were found guilty and if there are judgments that they need to prove up, if they're trying to prove up prior convictions. So it's not for this case. And when I say this case, it is not to prove whether he is guilty or not guilty in this case. That's before the court. It's for use if he were found guilty and if there were any prior judgments that they're trying to prove up or connect with Mr. Coleman for purposes of punishment, if it were to come to that.
That's correct, Judge. And it could also become an issue in the guilt phase of trial if the defendant chooses to testify and opens the door to certain other activities.
Well, then the question becomes then, does the state have any evidence that are related to fingerprints for proving the guilt or innocence of this case?
Hey, Judge, but if he takes a stand and says, I've never been arrested before, we may impeach him on that.
Well, I don't think anybody's going to be asking him a question if he's ever been arrested before. If anybody wants to ask that question, then defense, of course, you can ask whatever questions you want to ask. But state, if you want to ask that question, you need to approach before asking that question.
Of course.
Okay.
I just have to anticipate every possibility, and it may be possible that that door gets opened during the guilt phase of trial.
Okay. So my understanding from the state is that that is what the list of witnesses for fingerprints is for. It is not for proving whether or not he's guilty or not guilty of this case. It's to be used if necessary during punishment or if the defense were somehow to open the door. But even then, the issue will be whether or not he's going to be fingerprinted or not, which we'll cross that bridge when we come to it. So
Judge, the only comment that I would have in regard to that is Paul Dagger, who is the police officer, was the one who took the fingerprints and found that there was no match. And he is not listed under the fingerprint examiners as someone. So if they have access to any information from Paul Dagger, we did not see any of that information in discovery.
all right, and when you say information and discovery, are you saying you didn't
I did
receive?
not get a report, only the conclusion of the matter, which was in his written, police, report that there was no fingerprint match.
All right. Was there some sort of report that was done?
Not as far as I know, Judge. Not beyond what's been tendered to the defense already.
All right, so there is no report on fingerprint.
Not as far as I know, Judge.
No, I mean, it's like, well, not as far as you know. Do you have any fingerprints, documentation, or anything that they've used to make a determination of whether or not the prints are Mr. Coleman's or not Mr. McColeman's, or the prints are inconclusive? Do you have any of that, the actual science behind it and what they did to make that determination? Is that in your possession?
No, Judge.
All right. And do you know if it's in the possession of any witness that you're going to call?
I haven't made a specific inquiry. If the court would like, I can ask if you're asking about underlying scientific.
Yes, I'm asking, what testing did they do to make that determination? Do you have?
Well, I think there's a discussion that in the police report, it's not like, there is a report that mentions the fingerprint, which was turned over to the defense.
No, I mean, the actual, if there's a report out there that says, this is the analysis I use to make a determination on whether or not the fingerprint belonged to the defendant, and they're looking under the microscope or whatever they're doing and saying, this is what I found when I looked under the microscope, or this is what I found when I did this. That's the report that I think the defense wants to know if you have.
We do not have that.
All right. And does your witness have it, or did your witness do what sometimes fingerprint examiners will do? They come to court, they look at it, and then look at this and say, these prints match or they don't match. Are you telling the court that's all that was done?
As far as I know, the defendant hasn't been fingerprinted yet for this case. Like there hasn't been a fingerprint.
No, I'm talking about defense is saying that they received a report that there were some fingerprints that were inconclusive. While they're discussing that, Ms. Cantrell, what's happening with your case?
We're gonna ask for a reset today.
All right, Caroline, could I see Mr. Cantrell's file? It's David White. Where's Mr. White? Come down. All right, what's happening with this case?
Well, Judge, can I just approach?
Yes.
Just, can you mute us, please?
A 45-day reset on Mr. White, please. All right, we'll be back on May 4th.
Thank you, Judge.
You're welcome. All right, are you all ready to address that issue?
Yes, sir. Are you ready first?
Yes.
So I'm sorry, I guess I misunderstood what the defense was asking about. There was a CSI that had mentioned that there were prints with negative results. My understanding is that they attempted to look latent fingerprints and were not successful in that. I can clarify that with the CSI, but as far as I know, there is no fingerprint report, and there were no successful fingerprints taken.
Okay. All right, they're saying defense that there is no fingerprints that were able to be lifted, or if something was lifted, it wasn't enough to make a comparison. So if for some reason that changes, then before anything is placed before the jury, we'll do that outside the presence of the jury. All right, let's start. So number 2 appears to be extraneous. Is that correct? offenses?
Yes, so Judge, this is one of the paragraphs that appears to be a motion in limine. Again, if the defense is raising objections for the purposes of preserving error, we object that is not timely. If they're just merely requesting a motion in limine for that, for extraneous conduct, we have no objection to that.
All right, so with regards to number 2 defense, just ask both parties if there's any thing that is extraneous, just ask to approach the court before going into that and questioning any witnesses about it. So I will put that parties will approach. All right, are there any expert witnesses in this case? Defense? I'm sorry, defense or state? Are there any expert witnesses?
The state has given notice that officers and 911 custodians and the fingerprint examiners that were previously mentioned may testify as experts. At this time, we don't anticipate a need for them to testify as experts, but it could be possible that they need to talk about police training or investigation in that context.
All right, and defense, do you, when you say expert in opinions, are you talking about any doctors or are you talking about the custodial records or for the 911 call?
I am specifically talking about, my mission won't do this with medical records. But, anytime we have an expert that's gonna testify, we would like to be able to dial them outside the presence of the jurors.
All right, everyone, just approach. Because I don't know who or if there will be any experts necessarily. So just approach on that. Inadmissible opinion testimony. All right, that will be on that one.
We would just object to the last few sentences of that paragraph. Before we get to the numbered paragraphs, the last two sentences of the first paragraph where it says no allusion to the testimony in the opening statement or case in chief. I believe that we're allowed to talk about evidence that we reasonably expect the trial would show. Obviously, if we fail to produce something that we expect to prove, the defense can mention that and accuse us of that in their closing arguments. But if we reasonably believe that the evidence would present that, that the evidence will show that during trial, I believe that we should be entitled to talk about it during the stage.
Yes, they will be allowed to talk about what they expect the evidence to show in opening statements, defense.
Again, Judge, I'm sorry.
The state will be allowed to talk about what they expect their evidence to show in opening statements. And of course, if they don't produce it, they don't produce it. So, yes, with regards to the last statement, nor should the state be allowed to allude in any way to the existence of such testimony in their opening statement. In their opening statement, everyone is allowed to say what they expect the evidence to show. And then if they don't prove what they said in their opening statement, then people can cover that however they wish to cover it. And let's go, because you have number 4, you have an inadmissible opinion testimony, then number 1. Number 1, opinion testimony concerning the alleged bruises of the skin. I don't know what the testimony is going to be. For example, with the opinion testimony, if the complainant is testifying and saying, hey, this is a bruise, this is not a hickey, then that's, I don't see at this point how that would not be admissible. So with regards to opinion testimony, that will have to be determined when I hear more about this case and hear what a witness says. Now, understand that neither party wants a lay witness testifying as though they're an expert in some field or a doctor. For example, I'm not expecting, and I could be wrong, but I'm not expecting the state to call a police officer and to say, this was clearly caused by ABC, based upon my medical training, if they don't have medical training. So that number one, I'll have to wait and see what the testimony is going to be, because I don't know what the testimony will be. Now with number three, with regards to whether or not the defendant acted intentionally, no witness is allowed to say, to say that the defendant acted intentionally. I don't think any witness would say that. If somebody, for example, shot someone, they would say, well, this defendant took the gun out of his pocket. This defendant did this. This defendant pointed it at them. This defendant shot them. Then people can assume that's intentional. But I don't know of any case I've seen where a lay witness or an expert witness says someone acted intentionally. State?
We agree with board. We don't intend to elicit that kind of specific testimony.
All right. So number three, that will be granted.
Judge, in number one, I'm just going back a little bit. Again, my big issue with this case is going and presenting evidence in regard to any type of medical issue, okay? In regard to EMS, which I noticed on their witness list, they did not list EMS as a witness. But in the EMS report, it states that there were no injuries.
Well, here's the thing.
Later on, she comes back and said that she did have injuries.
Well, here's the thing, though. If there is a witness that's being presented that is not on your witness list, then that witness may not testify. I mean, if there are EMS workers and EMS workers are called to testify and they're not on your witness list that's been tendered by the state, then they're probably not going to testify.
Well, one of the issues is on EMS. Okay, when EMS arrived on the scene, they made an assessment that there were no injuries and she did not receive treatment. However, on the witness list, that name of the EMS person is not reported. We do want the name of the EMS.
All right. Do you know the name of the EMS worker?
Yes.
All right. Have they been subpoenaed? All right. Defense, do you want to subpoena the EMS worker?
Yes, whoever it is.
All right. So subpoena the EMS worker and.
I need their name though.
Okay.
Their
All right.
name.
All right. So state if you can give her the name of the EMS worker, if you know the name of the EMS worker.
We don't have any EMS.
All right. So, all right. We're going to cut this hearing. I'm going to have you guys take a break. So if there's an EMS person that came out to the scene and evaluated her, surely there should be some documentation somewhere, either from the CSI person or either from the detective to say, we were called out to the scene for, and what is this? For an aggravated robbery. We were called out because this person was injured. So there should be something there.
Judge, the reason why we know EMS is there is that it's in one of the offense. And it specifically states that upon my arrival, I made contact with victim one who said she was in pain. B1 was checked by EMS and found to have no injury. This is exculpatory evidence, but somehow there is no EMS report or no information.
All right, so we're going to recess. We're going to take a lunch break. State, obviously, there is what defense counsel is reading is from the police report. There is an EMS worker. Did the review to see if the detective or whoever came out to the scene got the name of the EMS record, the EMS record? There should be a bill for EMS. EMS is just not traveling out to locations for free. So there should be a bill somewhere for EMS. There should be some sort of call out from EMS that there should be a record of the call out so people know who the EMS worker was, when they were called out. That should be in some kind of incident detail report or somewhere. So if this whole case is hinging on whether or not there were injuries or not injuries, or somebody saying they had injuries and they actually didn't have injuries, then yes, that could be considered exculpatory. So people need to find that EMS personnel, whoever that is. We're going to take a break and find out who the EMS worker is, where they are.
That's fine, Judge. I can do that. To the point about it being exculpatory evidence, we're not alleging bodily injury in the indictment. We're alleging threatened or place fear within the bodily injury.
But, and I don't know anything about this case, but if the complaining witness, and mind you, this is just me based upon discussions that both state and defense have had in the court's presence. If the complaining witness is saying they were injured because of this aggravated robbery and there were injuries to them, and EMS was called out to the scene and there are not injuries, even though the complaining witness said there were injuries, that's exculpatory.
It would be impeachment.
Yeah. Yes. So, and they're entitled to it. So we're,
Judge, I know we're in a hurry.
no, we're not in a hurry, but I'm going to take my lunch break. I'm going to give the court reporter a chance to take her lunch break, and everybody needs to find out. And by everybody, I mean state, find out who that EMS worker was who came out. It should be in the incident detail report that an EMS worker was out there, and we should know the number of what's on the truck, because all of them have numbers that are associated with specific teams who go out there. And then once that's discovered, they should be able to look on their system to see who was called out on this date at this time.